Deputy Tommy Broughan.
Thanks, Lascan. I'm delighted to have the opportunity to speak briefly on this very important bill before us today, the Courts No. 2 Bill 2016. It's co-sponsored by the Taoiseach, and I understand it's a collaborative effort with the Minister for Transport, Tourism and Sport. And it allowed for the commencement, at long last, of Section 44 of the Road Traffic Act 2010, the third payment option, which I've been calling for in this House for a long number of years, Lascan. Indeed, I have PQ replies dating back to 2012 with the previous Minister for Justice, Deputy Shatter, and the Minister for Transport, Tourism and Sport, Deputy Varadkar, at the time stating that my officials, I quote, are also in consultation with the relevant stakeholders, including the Department of Justice and Equality and the Gardaí, regarding the commencement of Section 44 of the 2010 Act. I expect to receive an update on these consultations shortly, and that's about 4.5–5 years ago. As soon as the Department of Justice and Equality advised that the technical and administrative measures are resolved, Minister Varadkar undertook to immediately commence Section 44. And as I said, here we are 4.5 years later. In 2013, I got a similar reply, I think, from former Minister Shatter. He referred, in fact, to a working group on this whole area. The working group in question is the Criminal Justice Fixed Charge Processing System Working Group, which is set up to examine the serious failings in the processing of fixed charge notices and the application of penalty points for road traffic offences. Currently, of course, if a person is convicted of a fixed charge offence, they are issued with a fixed charge notice indicating the detail of the offences and giving them 28 days to pay the specified fine. A further 28 days payment period is then permitted, plus a 50% increase in the fine amount, a total of 56 days to pay if the fixed charge notice remains unpaid. So the bill before us finally provides a legislative framework to allow for the commencement of Section 44 of the Road Traffic Act 2010, also known, of course, as the third payment option, and provide persons with a third and final opportunity to pay the fixed charge plus 100% extra and therefore avoid a court appearance. The third FCN, most importantly, will be issued alongside the summons for the court appearance, therefore putting a stop to the practice of those incurring fixed charge notices attending court and claiming that the fixed charge notice were never received. So this generally culminated in the case being thrown out, no fine paid and no penalty points being applied to the licence. That practice, of course, is widespread, and legally there seems to be little that a judge can do but accept the word of the person before them, meaning that tens of thousands of fixed charge offences were thrown out of courts each year. This short bill then will amend Section 1 of the Courts No. 3 Act 1986. Section 2 of the Courts No. 2 Bill 2016 inserts the subsection into Section 1 of the 1986 Act, making 6 amendments in relation to the administrative procedures of printing and issuing summonses. And paragraph A of subsection 2A provides for information sharing to allow print service provider print a summons and fixed charge notice. Paragraph B allows for the processing of batches of summons, and paragraph C, D, E and F make provisions for the definitions around the effecting of the summons and true copies of the summons. And Section 3 of today's bill deals specifically with the issuing of summonses to a member of An Garda Síochána when he or she has allegedly committed a road traffic offence. A summons to a guard, of course, no longer have to be signed by a judge, as is currently the case under Section 88(3) of the 1924 Courts of Justice Act. So, Minister, I warmly welcome the bill at long last brought forward, and I wish it a speedy passage through the House, which it is getting. But let me also use the opportunity of this debate to raise 5 or 6 connected and closely related matters, which I would hope the Minister for Justice on her side would address. As you know, the Department of Justice and the Department of Transport together, if you like, have to work very closely to administer road traffic law. On November 3rd last, the Taoiseach told me in a parliamentary question I raised on the wording of the summons to inform persons of the legal requirement to present their driving licence to the court and the penalties for failing to do so. This is Section 22 of the Road Traffic Act 2002. She answered me on this particular issue, but the issue still it hasn't been, as far as I can see, effectively addressed in this House. So when will this be rectified? The enforcement of Section 22 remains a huge issue in our road safety legislation. The reason is, in November 2015, Justice Marie Keane dismissed the 21 cases before her for the offence of failing to produce their licences in court and ruled that the summonses were, and I quote, quote, fundamentally flawed, because a person who comes before the court is entitled to know the consequences that flow from not having produced their licence. I've been asking since this ruling what's been done to correct the wording on the summons on these Section 22s so that Gardaí can begin to prosecute again. And in November 2015, the Taoiseach told me, and I quote, "I'm informed by the Gardaí authorities that in the first instance an offence wording is created by an Garda Síochána. Following approval by the DPP, the approved details are forwarded to the court service for offence coding, returned then to an Garda Síochána for uploading into the Garda's Pulse system. This then allows a member of an Garda Síochána to apply for a summons by inputting the specific offence code assigned to the particular offence in respect of which they are creating the summons for. A complicated system, as you'll agree, Lascan. However, it's now 15 months since Judge Keane's ruling, and despite many promises of an urgent report, I have not received any update. And the Taoiseach said on 15th of November last, and I quote, "Insofar as the wording of the relevant summons is concerned, an Garda Síochána is engaged with the prosecution authorities in relation to these issues, which I understand are complex ones and are not necessarily related solely to the wording of the summons. And as the Deputy will be aware, I have asked an Garda Síochána for an urgent report in this regard. In addition, the wording on the summons and other related matters are being considered by the Fixed Charge Processing Group, which is jointly chaired by my department and the Department of Transport." So what's the outcome, Minister, of the consideration by this group on this outstanding Section 22? Laskin Corla, it's of course the responsibility of an Garda Síochána to serve summonses. Figures from PQ replies show, however, it's not being done in 37% to 85% of traffic cases across the country. The Minister of Transport and the Taoiseach, I think, need to work very closely together again on this whole ineffective system and start to find solutions. It's difficult to understand, for example, how the reasons so far put forward by an Garda Síochána could account for the figures. For example, I'll just take 2 or 3 examples at random. Lascan, Manor Hamilton, for example, 85%, where a small area where most people are likely to be known, that the Gardaí would know their area, and where residents are unlikely to live in multi-occupancy dwellings inaccessible to Gardaí, or the 67% rate of non-serving in Skibbereen, or the 62% in Ballahadreen in Roscommon. The reason provided me by way of PQ on the 15th of November 2016, when I requested information on speeding summonses, the Taoiseach said, I quote, "The figures provided by the court service indicate that a significant percentage of cases are struck out for non-service. My officials are seeking clarification from the court service and on Garda Síochána as to the reason for this figure being at this level. It should, however, be noted in this respect that a working group, another working group, Lascan, was established by Garda Síochána to examine how the rate of summons serving can be improved and to regularly monitor the level of summons service throughout the country. While the group has reported improvements in the rate of successful service of summons, challenges remain in relation to affecting service of summons in certain circumstances relating to matters such as inaccurate address data, persons moving address or living in multi-occupancy dwellings or other settings which make service of summons difficulty. And of course another reason that people, other persons, she says, will take steps to evade the service. But in the period from January 2015 to October 2016, there were 66,771 offences listed for speeding in courts across the country. Of these, there were just 14,572 convictions, and that's just over 20%. And of these convictions, so 6,165 had their licences recorded. 42%, well under half, were dismissed. 30,618 were classified as, quote, strike out, not served, equating to 45%, almost half, and 676, of course, received the court poor box, which is technically illegal. And the total convictions of 48,745 mean that 73% of offences listed resulted in non-conviction. A third matter that I wanted to raise briefly with the Minister, and which relates to the performance of the Department of Justice in relation to road traffic law, concerns figures released to me by the RSA, which show that 96% of drivers disqualified in courts did not surrender their licences in 2015. Recent figures released, actually these figures were released to the great campaigning road safety group Park, who have under Ms Susan Gray and her colleagues who have done so much, I think, to bring forward a lot of the road safety issues in this House. Recent figures released by the RSA, of course, the Irish Times, show that almost 8,000 drivers who have multiple concurrent disqualifications on their licences continue to flout the law by driving. And these are drivers who are ordered off our roads for drink driving and or causing death or serious injury. The Times also reported that banned drivers are responsible for the deaths of between 11 to 14 other drivers every year. We already know, Lascan, that 521 drivers were disqualified at the time they were convicted of dangerous driving causing death or serious injury in the period January 2013 to March 2015. To date, the Road Safety Campaigning Organisation, PARC, and myself through PQs, we failed to establish how many of these drivers were already disqualified at the time they caused death or serious injury. And perhaps that's another matter that the Minister for Justice could, urgently progress, because there does seem to be, Minister, and I think you've always been a very thoughtful and assiduous member of this House, and similarly now as a Minister, it does seem there are huge lacunas in the whole area of road traffic law enforcement and administration, which we need to resolve. I said to the Minister for Transport earlier on that he promised, I think, 4 pieces of legislation in relation to road traffic law, his side of road traffic law, and maybe it's time we did a consolidated bill and brought it as something that this government could work on. I note that Minister Ross recently in a PQ, where I requested a full report which the RSA had carried out in relation to the 8,000 figure I gave above, he replied to me, and I quote, "I'm aware of the Road Safety Authority research indicating that there may be as many as 8,000 disqualified drivers on our roads, and a number of them have been responsible for fatal or major collisions in recent years." He says then, "My department have been advised by the RSA that this research was not the subject of a formal report," so it's a report we don't seem to be able to get in this House, and the RSA research included the use of data provided by the National Vehicle and Driver File to the RSA. And the reply went on to say, and I would point out, under new powers provided to the Gardaí under the Road Traffic Act 2014, the Gardaí since June 2015 can now arrest drivers who are detected driving while disqualified. Another issue that I just briefly want to raise with your Minister this evening, Gardaí have also informed representatives of the PARC organisation that on occasion when they go in to check an individual on the Garda Pulse computer system, it's not possible to identify the correct person. They say this is due to the fact that there could be several recorded dates of birth for that person and differing addresses. The result in multiple pulse is multiple pulse identifications, and they say it's not possible for Gardaí to be confident that they are identifying the correct person. So what's been done to identify this on the Garda Pulse computer system, and are you sure, Minister, that the Pulse system is fit for purpose? I mean, it's not too long ago in this House, I feel we haven't supported An Garda Síochána sufficiently well in relation to IT structures and in relation to support in the whole computer internet age, because it's not too long, you remember, Minister, that myself and yourself, when we were contacting our local Garda headquarters, we couldn't email them. It's only really relatively few years since we could actually email our local super or chief super. I've also requested, just a sixth brief point, an update on the drink driving cases which are affected by the issuing of Garda reports in both Irish and English, and have been informed that the information I requested cannot be provided, Lascan. The Taoiseach, however, did tell me that the matter, she says, was determined by Noonan J at the High Court on the 21st September 2015. And An Garda Síochána sought to have all cases where this issue had relevance before the courts at the time adjourned, pending an appeal of the High Court decision. End quote. In certain cases, the presiding judge didn't accede to that request, continuation of the quote there, and the matter was struck out or dismissed. End quote. The Minister also informed, Taoiseach also informed me that, and I quote, following the judgment by Edwards J in the Court of Appeal on 10 May 2016, all district officers liaised with the respective law officers insofar as the case in their district were affected by the outcome of these proceedings to ensure that all cases affected by this issue which have not been finalised are brought back before the courts. So it would be useful, I think, if the Taoiseach was able to come in here and give us an update on this serious matter, which has led to another huge gap in people owning up to their responsibilities in relation to different infractions of road traffic law. We had a very good discussion, I think, in the House, deputy beside me and others took part in relation to the road traffic bill before Christmas. I think most people feel still that more emphasis needs to be put on learner drivers also. I've recently been asking questions around this and have been trying to determine the extent of the issue with unaccompanied learner drivers being involved in fatal and serious road traffic collisions. I received a PQ from the Taoiseach at the beginning of the year informing me that the number of fatal traffic collisions collisions involved unaccompanied learner drivers was 7 in 2012, 4 in 2013, 8 in 2014, 16 in 2015 and 7 up to the 29th of November 2016. And unaccompanied drivers involved in serious road traffic collisions were 22 in 2012, 10 in 2013, 32 in 2014, 24 in 2015 and 24 up to the 29th of November 2016. I hope the measures, we had a long discussion about insurance of cars being driven by learner drivers in the lengthy discussions on the road traffic bill, and I hope that the changes in the law there will in fact move towards eliminating this scourge and the numbers here of deaths and a serious injury being caused by unaccompanied learner drivers. So in conclusion, Minister, there are a number of provisions I would like the Minister to urgently examine. They could be included in this bill if she was to take a swift and decisive action, such as addressing the wording of summons and the time frame to have changes completed, and for those to be issued along with the fixed charge notice, but also those to allow prosecutions under Section 22, in particular Section 22 Lascan of the Road Traffic Act 2002, that would be allowed to recommence. I'd also like to see provisions stating that where the licence or permit is produced on conviction, all the details specified in that licence or learner permit, including the licence number, must be forwarded by the court to the National Vehicle and Driver File and the RSA within 5 working days, and including all of the names and contact details of the persons who failed to produce their licence on conviction. I tried to put that into the road traffic bill before Christmas, because this is for this, I think, a direct or electronic link between prosecutions as recorded on the Court Service Criminal Case Tracking System, the CCTS, and the fixed charge notice originally issued by on Garda. We need to have that specific connection. We need stronger penalties for those who don't surrender their licences, and of course improved follow-up to ensure that proper tracking is taking place of licences and the endorsements received on those licences. And I think last year, Minister, of course, we were all very disappointed with the numbers of deaths on Irish roads, that it went up so significantly to 188. Huge efforts were made, I think, by deputies on all sides of the House to reform road traffic law over the previous decade and a half. We brought the numbers down from the horrendous figures that used to exist, say, in the 1960s and 1970s, but still 188 families totally devastated, and then thousands of families with people who are seriously injured. We need to take a very proactive policy, and I believe it's an area where your government and particularly the Taoiseach and Minister Ross could make a significant contribution, if you wish, as I said, perhaps by consolidating road traffic law and having the courage to bring a consolidated bill before the House. But I commend the bill as it is, last count, to the House. Thanks.